Yes.
I think one.
Pass on the memo.
The auction scheduled today.
Yes, pass on the memo. It can't be, it will be listed tomorrow.
If it is a matter pertaining to the large scale of consumption of electricity at Bantu Pradesh,
Sir, pass on the memo. It will be listed. Don't worry.
pay for next week.
Right up tomorrow is very early.
We already instructed. Please pass on the memos.
Related to constitutional.
Yes, please pass on the memo.
Constitutional benchmark before the Deputy then Honorable Justice Board.
Tomorrow is an option.
Item number 1.
Madam, this is regarding the first part of the Honorable Supreme Court. Giving us the liberty to Honorable Court for releasing some amount to the repositories for this Honorable Court in the execution petition.
Is the other side. What is this application? Where is the order of the Supreme Court?
May I speak some facts before my begins?
Order of the Supreme Court Honorable matter that this is IA number 3 of 2025. The order is annexure 111 to 15.
Annexure?
Annexure IA number 3 of 2025. That is annexure 111 to 15.
IA 3.
Yes, sir.
Yes.
Page number 13, paragraph 8.
Now this execution appeal is pending.
Yes.
Why-
First appeal is pending. Execution case was disposed by the Honorable.
It is appearing before us?
Yes, please.
It is today for orders minute for limited purpose. Let me explain if I.
Can we go for a appeal to be decided?
That's
My lord,
right.
against the order to this Honorable Court passed in execution case number 2 of 2015 in 11/8/2017 by Honorable Judge of this Honorable Court. We had moved before the Honorable Supreme Court by filing one SLP 3862 of 2017, which was disposed with this direction. Dated 3
No, that I have seen
2025.
liberty to move an application, the pending intra-court appeal for release of some amount in your favor.
Yes, my lord. This is the order of this Honorable Court.
So this, first
So we
you
have
tell
filed
us,
the
that this execution case originates from which?
This case originates from.
Let me have a facts first. Yes,
Brief fact of the case is that
yes.
the state government, in order to facilitate the public, had taken our land in one town.
So this is for public purpose, they acquired the land
Yes, public.
under Act 1 or 2013 Act?
Not
No,
accurate.
it was not under the Land Acquisition Act.
Oh.
It was under one town planning scheme, which was, we were directed to give some land, and we had given. Against that, we did not get in compensation.
Correct.
We, in spite of several representations, since they did not consider our representation, we filed one OJC before this Honorable Court, being the OJC number 11,342 of 2000, and that was disposed in 2009 with the order that state is directed to give equivalent extent of land to the extent of 1 acre 1837 decimal, having the similar potential value.
Correct.
Then against that order, the government went to the Supreme Court by
Correct.
filing on SLP.
Correct.
Then in that SLP, the order of this Honorable Court passed in 11,342 2000 was upheld. And-
Upheld.
Yes, ma'am.
Yes,
Then
then
state was directed to give the equal extent of land having the similar potential value. If the state finds no suitable land, they are permitted to pay the market value of the land.
correct.
So in between, since within the specific period they did not allot us the suitable land, we filed one contempt case.
Correct.
During the pendency of the contentious, they allotted one land in Bhubaneswar, which was 14 kilometers away from the land given by the petitioner.
Which is?
That was, that land was not potential.
Okay.
It was 1/10 of the value of the land they had taken from the petitioner. So it did not accept that land. So court told that that is not as per the value of the land. Let the market value of the land be determined. Accordingly, Honorable Supreme Court, according with the consent of both the parties, appointed Justice R.K. Patra, now he is expired. So, as arbitrator to determine the value of the land. Having taken all the government records, visiting the spot personally, and taking the these witnesses.
Then the value was determined.
Value was determined at the
What
rate
was
of
the
14
value?
crores per acre and not less than that. 14 crores per acre and not less than that. In
14 crores
2014.
per acre.
Yes, ma'am.
Yes. Then
Then
did they challenge that particular
the
award of?
Well,
Did they challenge the award of the
Yes, ma'am.
arbitrator?
not that they filed an objection before the Honorable Court in that content petition.
Honorable court means
Apex suit.
apex.
Yes, ma'am.
Yes.
In that content petition, Honorable Supreme Court directed that you are at liberty to file the execution of the order passed in your favor. So we
That
filed-
means the award was upheld.
Yes, ma'am. It may be treated as it is deemed to be approved.
No.
Deemed to be approved.
Where is that order of the Supreme Court? Where is the order of the Supreme Court?
Then we filed this execution. Then we filed this execution being the.
Where is the order of that Supreme Court? That
No, Lord, I'm just.
where is that order?
Your Lordship may see the execution fact appeal number 1 of 2017.
Give me the page number.
So I'm giving this fact. It's on page 48 of the execution fact appeal number 1 of 2017.
Page
48.
48.
Yes, Mr.
Uh, Execution petition, annexure 5.
Against the
This is annexure 5.
Contemplation number 202.
Yes. Page 48.
48.
Yes.
Paragraph number 19.
Paragraph?
19. 19.
Yes.
That thereafter, Honorable Supreme Court heard the parties and disposed of the contempt petition.
So they say not a willful or deliberate violation of the order. So despite the observations, it is open to the respondents to execute the order passed in their favor in accordance with law. No difficulty. So you were
Then we
permitted to
filed the
execute.
execution petition 2 of 2015 before the registered judicial of this Honorable Court.
Yes.
Then we filed it for 39 crores along with the interest. And he passed the order accordingly for the execution of the order.
Correct.
That was challenged by the state government before single judge,
Okay.
this court. Then whatever order was passed by the single judge, then we moved again to the Supreme Court. Then Supreme Court passed the
Directly
order.
from
Yes.
the order of the single bench.
Yes, my lord.
Okay. Then
Then the Honorable Supreme Court passed the order that matter will be taken up with the.
no, where was the
judicial
direction
side.
for deposit? Where was the direction for deposit? In what proceeding the direction for deposit?
Single judge order-
You want a release of some portion of the order, the money deposited in terms of the order of the court.
Yes, single
When that order was passed and who passed the order?
order was passed by Justice M.R.PATHAK.
I do not want the name.
Yes, ma'am.
Single bench.
Yes, the single judge passed that for the execution, for this, to stay the order of this registered judicial, you have to deposit the money as condition precedent. So they deposited 10 crores
Correct.
with this honorable court. Then thereafter the execution case was hard by again.
What was the order? That is the total amount or the amount which you admit?
They deposit
What
part
what
of
was
that-
the order?
Part of the amount. Part of the execution amount.
Okay.
then that amount is still is deposited with the
Correct,
register of the Honorable Court.
correct.
Then the matter was heard by the Honorable Civil Judge as per the order of the Supreme Court, who passed the order finally on 11/8/2017.
What it
Directing
is,
that as per the Stamp Act, it is fair to determine the market value as 7 crores per acre.
instead of 14 crores.
Yes, madam. 7 crores per acre. Then state government now has challenged that order here. As execution case number, execution first appeal number 1 of
So you have
2017.
accepted that it is a 7 crore per acre, no difficulty. Instead of 14
Then in a
crores per
concept-
acre, 7 crores you have accepted.
No, madam. We went to the Supreme Court against that order. Filing SLP 8862 of 2017. By
Right.
that order, in that SLP, order has now passed on 3/4/2005, which order, by virtue of which order, we have now moved on application for releasing some amount as per the direction of Honorable Court. We have moved for releasing some amount. And that appeal is 1 of 2017. My Lord has directed that let the value determined by Justice Patra be examined by Honorable Court, this Honorable Court.
Where is the order that to be examined?
This is,
Para 6 of the list.
Down below L3.
Oh, that's appeal is disposed of with the signed order. I do not know where is the signed order.
Yes, please.
Huh?
Take this place.
Lord, may I assist to Lordship? Para 6 your Lordship may peruse. Shall the order, last order, that is the final order of the apex court, para 6.
Para
That is
6.
very important. That is the crux. Everything merges here, my Lord, all are there.
So the question is that so far as the order of Justice Patro, who acts as an arbitrator to
Right.
determine it, whether the value of the market value of the land as determined by him is the exact market value or not to be decided by us.
Yes,
Right.
yes, Miller. Yes, Miller.
This is the only
Yes,
crux.
Miller.
Now he has decided 14 crores per
Right.
acre.
Hello.
Single bench has reduced it to 7 crores.
Yes, Miller.
You have challenged the appeal in the appeal. You have filed an appeal.
This order has been challenged by state government before your Lordship.
Then what logically deduced therefrom that you have accepted that value of 7 crores?
No, Miller, we have not
Then-
accepted.
Have you filed a cross objection?
We have not accepted, therefore we had moved to the Honorable Supreme Court, challenging that order of this Honorable Court single judge order, that the value determined by the execution case now 2/15 is not accepted by us. In this paragraph,
Have been deposited,
my lord,
10 crores.
we have paid for 10 crores, but it is up to your lordship,
How much has been deposited? 10 crores.
10 crores, 10 crores in 2016.
Oh,
Yes.
you have made out an application, so that certain amount we will give it.
My lord.
Anything more you want to say?
As per the terms and conditions to be decided by your lordship, as per your discussion.
So, that we can put you on terms, that whatever we.
As their lordship pleases.
Yes. So that's the only thing.
Yes, sir.
Let us hear learned adequate general.
My lord.
Should we hear now?
Yes, my lord. Yes, my lord. Yes, my lord. I have nothing.
Yes.
Your lordship is absolutely right at the outset. There is no cross appeal number one. Para 6, your lordship have already gone through.
6 is such a cows dinner language. We have to dispense with all these things.
Right.
Now it is appointing the writ at large.
Right.
Now the question is.
It's very broad and open. Now you have to go.
I am telling you that what we perceive, that we can decide in your appeal whether the 7 crore per acre is correct or it should be 14 crores.
Or it will be nothing. Milord, I'll explain. No. Why I am
That is
submitting
what I
it
said.
here?
No, nothing is possible.
Nothing is very much possible.
No,
I will explain, my lord.
That
That is the whole thing.
you could not gather what we wanted to say. The moment
Sorry.
you challenge the order determining 7 crores
Right.
per acre,
Right.
that means the appellate court will normally, ordinarily, I am using those two expressions,
Right.
will decide whether the 7 crore is the market value. Be less.
Yes.
It may be less, maybe it may come to 0.
Right.
Whether the court can, in that appeal, say, no, 7 crore is not proper, 14 crore is proper.
Your lordship.
Your appeal.
Yes. Everything is now in our lordship's domain.
But this is normally, ordinarily not done. Because they have neither filed a cross appeal nor a cross objection. But
Right.
paragraph 6, it opens a Pandora box for him.
Right.
May I use the
Absolutely.
term?
Absolutely. That is
So now we can even in your appeal can go up to 14 crores.
right, Milord. I don't
Now
dispute.
tell me that you have deposited 10 crores.
10
You have
crores.
taken his land.
Madam.
Now, according to him, that alternative land is required to be provided to him. That was provided, but that does not appear to him that it is matching with the market value of the land which you take from him. So he resisted. Then there was already an order of the Supreme Court appointing Justice Patra as an arbitrator to determine the market value.
Right. Exactly, Milord. We may not say
Analyze the
arbitrate.
situation. Can we go back to square one? I understand where you led. If my anticipation is correct.
Not section 11. I'll
For not section 11.
Yes.
It's not a section.
But
It's a
what-
statutory arbitration.
Yes.
It's a
Yes.
statutory arbitration.
Right.
Sir. There's no difficulty.
Right.
So what is troubling us is this. That the refusal to accept the alternative land was improper.
True.
That cannot be gone into at this stage after Justice Patno is appointed.
No, that is not all. Let me go
That
for
is what troubles us. Now you clarified.
Yes, Milord. few
Because you were
things.
heading for that if I anticipated your.
Milord, absolutely, your lordship is correct. Milord, we can traverse beyond law. Is two things. Milord, it's basically, I do not know how all those proceedings have been conducted. I have discussed with the entire officers of the GD department, including the chief secretary. If we go to the genesis, Milord, he is a builder. In fact, the adjacent lands he constructed building and sold it. So the residents of those apartment owners, just a minute,
Please do not.
it's not the way,
Excuse me.
not the way.
Let him finish.
I was also Milord arguing this matter in the Supreme Court. I am more conscious of everything now. Please, whatever they have done, they have done, it's enough. Milord, this particular 3 pieces, plot number 353, was gifted to the government by way of 3 separate registered gift deeds. Land stands in the name of the present respondents in Sthitiban status. It has neither been acquired under any existing land acquisition act nor belong under any other law, state law. It is pure and simple a gift deed executed in favor of the Bhubaneswar Municipal Corporation, which is a separate body for the purpose of construction of a sewerage. And that is not for the benefit of any government project, it is only for the purpose of the dwellers in some private builded, constructed houses. But now we did not go ahead with that sewerage plan. Whatever much water has flown in the meantime, but the fact remains, he is not legally entitled to even a single pie from the government as compensation. Neither it is an acquisition under any existing land law, acquisition law, nor, my lord, I do not know how these things came in. But since para 6 now, my lord, merges all the orders, earlier orders, merges with the final order here, now I will leave it to your lordship's judicial domain discretion to decide to go into the whole thing, because it's an appeal. It's an execution appeal. Everything can be gone into now. The quantum determined by Justice Patra pursuant to an order. After the dropping of the content proceeding also, nothing has been directed by the Supreme Court. Even para 8, on which he is heavily relying upon for release of the some fund, your lordship, can you look at para 8 again? May I read it? The appellant shall be at liberty to move. And liberty has been given, it doesn't direct the High Court to release some money. Let the matter be gone into on merit. Since 15, the state has been resisting the claim, and the Supreme Court has finally left everything open. Let it be gone into on merit. I am prepared to argue on merits. So in a haphazard way, he can come, your worship, and look at the ground on which he has applied. He is a power of attorney holder. I do not, the power of attorney has also not been filed along with the IA for release of money. Who is he? Whether the other claimants have authorized him to go into it, and the purpose, para 8, your worship, para 8 of the IA. Let your lordship kindly have a clearance. For medical purposes, 10 crores. I don't think United States can afford such kind of medical treatment. 10 crores for medical expenses and without a single document. Court proceedings are not meant to be abused in such a fanciful manner. Para 8 of the IA. The whole thing is fraud. Whole thing. From the beginning, I do not know how could such kind of proceedings be conducted. Suit, even if yes. Even if your lordship knows, even if a suit, Milord, suppose some intermediate release is claimed for, you have to substantiate it. What is the legal necessity? Not even a scrap of paper to show that there is medical urgency, medical treatment is needed. And 10 crores, Milord. Which hospital in the country, Milord, will charge 10 crores for any treatment? I do not know. Ayushman Bharat is there. Right? I don't think that this requires we have filed a detailed objection. State exchequer money is not, it's not largest that we can distribute. And that too, he should have a legally founded claim. Supreme Court has
No, this is not a debate that you will. That's why I asked you, have you finished? When you say you have finished, I permitted it to. What is the amount? What is the land, total value of the land?
Land, my lord, it was
According to you, allegedly gifted to the municipal corporation.
not allegedly, my lord, it is gifted. The registered deeds are there. Gifted not for a public purpose.
I use the word for one reason, because I find here
Right,
that everything is called an LS.
right.
So that's why
That
I
is
say,
not
because he's not accepting the gift. He's not accepting the
I
gift.
don't think you will dispute. It's on record.
It is. When he asks for a compensation,
Right,
what is the effect of a gift? A gift is a voluntary act
right,
of a donor
right,
to transfer his property. It's a kind of a transfer
right,
in favor of a donor for some natural consideration, natural, not
right,
monetary
right,
consideration. Natural means out of love and affection,
right,
because of something he wanted to give.
right, you're right.
The moment the donee accepts
Right,
the gift,
right,
then the transfer is complete
right,
and it immediately passes the title
right,
from a donor to a donor.
right,
But the moment they come forward and ask for the compensation, alleging that the land has been acquired
right,
and utilized or used for such purposes
right,
without paying the compensation, then the question would be whether it is a gift
right,
or it is something which is otherwise.
right,
First and foremost question, this is what we found
right,
that troubles us is,
right.
can we enter into such aspect at this stage?
That is exactly what has also been said in the order of the Supreme Court.
Supreme Court, what it says, that's why I'm saying, kindly visualize.
Yes,
If your contention is accepted,
right,
then if it is a gift deed,
right,
then nobody is entitled to any compensation. Zero.
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 That is why, my lord,
I'm
yes,
coming,
Yes.
zero.
yes,
Because you have voluntarily done it.
right,
But the moment the Supreme Court appointed an arbitrator,
right,
that is Justice Patra, for the
Right.
purpose of determination of compensation,
right,
what it logically deduce, what can be logically deduced, that land cannot be treated as a gift. It is an acquisition by a government, and the
Right.
government is entitled to pay the compensation.
absolutely,
So if that comes, then the question of gift deed zero value does not arise now.
absolutely,
Now the question is that what should be the quantum of compensation?
right,
Whether Justice Patro's determination at 14 crores is an appropriate determination, or the single bench determination is a 7 crore is an appropriate determination. Right? Now we have to travel in between that, or this 7 crore is also very exorbitant.
right,
It should be less, maybe 1 lakh rupees, maybe 5 lakh rupees, maybe 10 lakh rupees, but it will be a compensation. So we cannot say that what was the nature of disposition now. It cannot enter into this. After this paragraph 6 is very clear.
Right.
That troubles us. Paragraph 6 says, it is a High Court in that appeal will determine whether the value determined by Justice Patro is correct, or the value of the single bench is also incorrect. So it is only the quantum which the court will decide, not any other aspect. Can it go?
Lord, may I humbly submit further, your lordship may kindly look at the last 4 lines.
Please look at that paragraph
Yes,
6.
that
That
is-
troubles me.
Lord, this was, Lord, very vigorously argued, this point was canvassed by the states.
Correct.
Lord, the state will be equally entitled to contain
Correct.
that the report of the order stroke determination.
Correct.
This is important.
Determination of what?
Determination.
Compensation.
Why justice? No,
What
why
no?
justice? Determination is below is too broad. Whether it's compensation or determination by justice Patra suffers from some legal flaws.
Correct. This is what it means.
One has to understand the determination. Justice Parker was appointed to determine what? The rights of the parties? No. To determine the market value of the property.
No, Lordship,
So this determination to arrive at the market value of the property is flawed, definitely. So the only thing is that whether he adopted the procedure which is required for determination correctly or not. So I just, that is what you were saying, that argument was available.
Right.
That once you have executed a deed of care voluntarily and you have not challenged that in the civil court.
it is not for any
It's an outcome
purpose.
of
Milord.
fraud or
That-
a caution or a misrepresentation or undue influence, whatever. Then in that event, you are bound by that particular execution of a deed. You can't reside therefrom. But that chapter, whatever be the reason, we do not want to make a comment, but that chapter.
Three things your Lordship may bear in mind. Number one, it was never for a public purpose. It was, three things. Your Lordship may go into it now. Why? The state is being asked to compensate, provided it is used for any public purpose. There is no public purpose. It's purely for the purpose of providing a drain to the dwellers of that particular locality, those who have purchased some private plots from him. He is holding. So you are
going to that be another line of thought that will come.
No,
If you
I am
are-
not going
if you are
beyond what
really
has been
polishing upon
stated.
that, then another line of thought. If you have agreed that in view of this property, you will give him another property, then it is now a conditional gift. It is not an absolute gift. Section 122, 23 of the Transfer of Property Act, if you look at, then it is a conditional gift. If the conditions are not fulfilled, then what?
I have to seek instruction on that. If that condition can be complied, this is very important. I concede
Just
to
one-
your Lordship.
just one-
Yes, Milord, I'm sorry.
Mr. Sir, why you are so impatient? Have patience, sir.
Just clarifying regarding the public purpose.
Required. My brother has just invited my attention to one order of the Supreme Court. If you come to page 64
Yes.
of the execution application, there is an order of the three-judge bench of the Supreme Court on 11/3/2024, 2014, sorry, stand from.
Is 64 million.
I could get from my.
I'm not getting one before Justice H.K.
No, it is Justice Gogoi and Justice Ramanna. That order of 11/3/2015.
According to Justice Patra Miller.
Correct,
That order.
correct.
I have gone through, but that may not be
Please,
just 64.
Please.
That is
62.
62 million.
62.
Correct.
Please come. Very
No,
first line
62
of
million is
the.
dropping the content was.
Sir, very first line of the second.
Yes.
After hearing and with the consent of both the parties, we pass the following order. What? In order to ascertain the market value prevailing as on the date of the property, where the description is given, then we appoint Mr. R.K. Patro, former Chief Justice of Sikkim High Court, is stationed at cutoff as arbitrator. We request the Honorable Judge to determine the market value prevailing as on date. I do not know what is the meaning of this. As observed in our order dated 9/1/2013, preferably within a period of 3 months. So, two things that emerge. One thing is that you consented for determination of the market value. You consented that, yes, this is the property.
So there was no instruction to Millard give consent. That is also clear, Millard. No, I'll. Let it
That knows the court.
No, any consideration your lordship knows.
The difficulty is
It's
you know the law better than anybody. If a Supreme Court has recorded a particular event, the consent, and the High Court says that this consent was not given.
No, that was
And you have to
argued,
approach
Millard,
the
I
Supreme
argued it
Court
before the
Before the
decision.
judge and say that why you have recorded the consent.
Millard, this,
You never gave a consent.
Millard, one second. That point I argued before this bench, the
Then
present
the High
order.
Court go into
That
this.
is why, Millard, your lordship said.
Huh?
Land has not been used by the government, it's still lying fallow. Millard, let him take back his land. Millard, let him, he is in possession. Land is lying below vacant and fallow. Stands recorded in his name. He is asking for compensation from the government at the rate of 14 crore per acre. That I do not know what would be the single judge. So therefore, Millard, we have gone in appeal. That is to be decided on merit. That let it be decided. All those points, Millard, we can raise now.
Probably we will decide it.
Millard,
We will
the
decide
element
what?
of fraud, the effect of a gift deed,
Again,
the
I'm
determination of
saying.
the arbitrator.
Mr.
So everything.
Advocate General, that is what we are inviting your attention to all these orders. Can we go back to scratch one and decide the everything after all these orders are passed by a Supreme Court? This
Yeah.
is what we really stuck up. We appreciate what you say, but
Millard,
can we
I'm
now entertain?
Millard, I am giving an example, Millard. Your lordship knows I will not delve into that, Millard, the bigger area, that fraud element that vitiates everything, that can reopen everything, Millard. Not one judgment. Your
I
lordship
can
is
give you
fully
a
concerned.
judgment, original
Millard,
judgment,
if I-
which is a Lazarus state.
Right.
It's an English judgment.
Yes,
The
so
Lazarus
that
state.
there is no
judgment
limitation.
which
I
says
can, Millard,
fraud
raise it at any point
unravels
of time.
every action. It makes any action taken on the teeth of a fraud is illegal, liable to be interfered with. The Supreme Court has also gone to a larger extent, says that the plea of fraud can also be agitated at any stage.
Any stage,
in
Your lordship, I am grateful.
All natural proceedings.
That's
I
correct.
know, I'm
That's
conscious.
correct. Your lordship,
But
I know
now-
your lordship is very
now
conversant
when you-
in that branch of civil law, so I can raise it now. And there is no written instruction to the award to make such a concession. It's not binding on the government. Had he been the advocate general, below your lordship, your lordship knows that law also. It is not a concession by the state. There is no written instruction. I argued that also before the Honorable Supreme Court, that such a concession is not binding on the state. It has not been acquired by the government. no compensation can be made. I can argue all those points now. Your Lordship may deal with it. It is up to your Lordship's domain how to deal with it. But there is an element of fraud, number one. This alternate land was nowhere. It for the first time immersed in Justice Kudusi's order. It was nowhere, not even in the gifting. Your Lordship may kindly look at page 51. It was nowhere. For the first time it came in a High Court. 88, this alternate land, that was not there, High Court order. This is the disturbing order. This order, your Lordship may kindly have a look at page 51, the division bench of this court. Nowhere, neither in the gift deed. Suddenly it emerges, you provide him land, why?
Just one. Come to case 31.
Page 35.
I'm thankful to my brother. Now I'm getting a
I know
assistant.
Justice Pathak is very thorough, both of you are so. No, can it be
Please come,
finally
please
hard?
come. That's
No,
the
that-
complete answer.
This is
What you are arguing, the complete answer to this. If you come to page 30, please look at
35.
please look at 35. That's a SMP which you find before the Supreme.
Page 35.
That is annexure
But I think
3.
the page numbers are not matching with this.
Annexure 3. Open it, page 35, Mr. Das. Open it. There's annexure 5, annexure 3.
Are your lordships looking at the appeal?
Order passed in
No, sir.
SLP.
It is the
No,
Supreme
sir,
Court
then it
order,
is not 35.
page 35, 9/1/2013,
One
which is annexure
One,
3,
one second. This brief is not, I think, this is not properly paginated.
which is annexure 3.
Supreme Court order. This one.
Accepted by the state.
It is equal. As per the signed order.
9/1. Have you seen who is the appellant there?
This is filed by Viranchina. State is not the applicant. The three judge bench order.
Two judges,
Order dated
Justice
11.
Sadasivam and Justice Jagdish Singh Kehat.
So it is not.
9/1/2013 order.
It's wrong. Jagdish Singh, Justice Kehar and Justice Babde.
No, Justice Sadasivam and Justice Kehat. Order dated 9/1/2013. Have you seen the appellant? Look at the order if it says. What?
18 that point. Now, this is the earlier order.
Yes,
That is the earlier order.
right.
So
And
now
there is a reference of this order in the last order. What it says, that is what I'm saying. The first thing is, we heard the learned counsel because you challenged the order of the High Court by which the High Court directed you to find out a alternative suitable land to be given to him. That means the High Court did not accept your contention that this land was never taken or given by way of a gift to you. Then it says, we do not find, it says the Supreme Court, by dismissing the special requisition, says that however, we do not find any valid and a legal ground for interference. The special writ petition is dismissed. However, the petitioner is granted 3 months' time to comply with the order of the High Court. Then, in case, if the state finds no suitable land as suggested by the High Court, they are permitted to pay the market value prevailing as on the date to the parties concerned. If that is the order, then what remains?
No, Milord, what I am suggesting, the interest of both parties are to be protected. Now, Milord, if your lordship would apply equity,
No,
State-
we can say a certain amount because this property cannot be said to be having no value. Can't say.
no, that
Every
that
whole
is,
property
no, Milord, that is
in the
not,
country
that
has
is
a
not
value.
my argument, Milord. I
So
don't
now-
say that.
Now what to do? Because he wanted some money and if he is entitled to certain part, may not be at 14 crores, may not be at 7 crores, at this stage we share. Then what should be the reasonable amount one can have from a robust common sense? If I apply those principles. At least some value.
Let the land,
Let them give an undertaking also,
let the-
or in any form of security, that in the event if you succeed, and the amount which is determined is less than what they have been permitted to.
let him
withdraw,
produce the
they
papers,
have
Milord.
to be-
Let him produce the bona fide papers.
What for?
Milord, your lordship, he is asking for medical expenses, number one. The appeal is pending.
Some
We-
money. we
No,
can-
your
we
lordship,
can provide.
there is no document, the power of attorney is also not there.
It is there.
No.
Given.
That power of attorney, your lordship knows how
It must
dangerous.
be there, otherwise.
Power of
Why do you have
attorney.
the power of attorney?
And
Everything-
medical expenses.
everything is there.
Anyhow, it will not be in the name of a power attorney holder, it will be in name of a principal. So it has to go to the principal, he is simply a agent.
Money is
Why
lying
the
in the
revenue of the-
registry of this court, interest bearing money has been deposited by the government in the High Court registry. Your lordship is the custodian of the money. Let it be finally hard any day convenient to your lordship, he is entitled, you will take. Lord, for 2000 he has been litigating, it is a checkered career. Everything is now again, Milord, in a topsy-turvy situation. We don't, the land is in his possession. He is asking compensation from the government. We don't. And let him take and use it. Let him take will. Let that gifted be revoked. And I humbly submit 3 things. Land is in his possession. He is the recorded tenant. It is still being used by him. Government doesn't require it for any public purpose. Let him take back. Revoke that gift it and take it back. He is in both the sides, his land are there. He has sold it to the builders. He now wants that this land, they want to use it for the private builders. Let him take back his land. That would be rather in the interest of justice, that if he wants to sell it to a third party, let him sell. Why should the state suffer? We will not use the land and pay him crores of compensation. In public interest, my lord, your lordship can go into that.
We appreciate every bit of your argument.
Let it be
We
finally had.
appreciate the
Let me
concern,
place
but
many things on
the
record.
law has to be respected.
That's correct.
And you know the
Let it-
principle that even if the law appears to be harsh, it has to be
No,
embraced. in such-
I don't stand, my lord, on that.
You can't say.
Let me
but
be
the
very
difficulty is
fair.
all these
It's
orders
not
are
my
staring at your
intention.
face.
No, I bow down. My intention is not to resist someone's claim if he's legally entitled. I have discussed, my lord, personally went to the spot, saw that it is still in his possession. We don't use the land. Government is serious about it. We want to settle it also. We do not want that a private litigant should go there, here, state should go there and here.
All these
Let him
things
take
that-
back the land.
Mr. Advocate.
We will
after
peacefully
this
hand over.
has happened, can we go into those aspects now? We, even if we accept your contention, even we appreciate the agony and the anguish having sown, but these orders are staring at our face. The difficulty is that
Let
it
me
is
put
stares
on
at
record.
our face, what we will do. We are also in phase. You are in trouble, but we are
That
in
it would
phase.
disturb the
What can we-
conscience of any person who is properly instructed
True,
in law.
but
It's
now
a
can you-
severe fraud on the state. I do not know this proceeding when I have gone through each and every document. Gift deed is still there. Let him not revoke that gift deed, and that is in favor of the municipal corporation also. It's a separate body. Why should the state pay? I fail to understand how those proceedings were also conducted. I'm surprised. Corporation is a different body. Party. State is also equally entitled to, my lord, get your lordship. I am begging before your lordship for public purpose. It's state's money. It's a public estate. It's not my money. It will not come to me. Lord, may I only suggest one thing? Let it be taken up for regular hearing. Certain documents, your lordship, my lord, what would be the ultimate outcome? Let me be very frank. I leave it to your lordship's
I think
judicial
this week you are
confined
free here.
conscience.
This week you are free here.
This week, the 24th, I will fit and I'll be outside. Any day, my lord, I don't want to fix my.
My lord, I
I
may
can
permitted,
virtually appear, no issue. That is not the.
my lord, I may be permitted 1 minute, 1 minute only.
Permit for 5 minutes.
No, only 1 minute. I will just show you one page only.
I have one question. We have gone into all the pages. Yeah. Yes, this week you are free.
This week means, my lord, from 24th, I'll be absent.
Which one?
24th, 25th, I'll be absent.
22nd.
Next week, not any date, I can bargain, my lord. Those dates, I can. And I should not be unreasonable.
24th.
What is convenient?
20
24th, I'll be out. I
Tomorrow,
take class
23rd. Tomorrow you are here.
23rd. Can it be on 30th, my lord? 30th. 30th. 30.
First matter and for argument.
Why should others suffer?
No.
At 4:30,
Because there is there is already a Supreme Court directions for disposal. I do not want that any of the parties should go and say that there is a reliance.
Let it be then part hard. Let go
No. I do not know, but my principles when I came from that side of the road to this side of the road, no matter what state partner.
Take up at 3:30 and some day.
That
No, I
will
don't
be
think-
taken up tomorrow because I am coming all along from Delhi and
So
every
what?
time I am coming and every time.
So why are you coming?
Some
You
day.
engage a local
Then
lawyer.
who-
Now we
who
are
will
going
do?
to Delhi also. to
No,
ask. That can't be the consideration.
You are saying
You can
several
have a
things.
special privilege that you are coming from Delhi.
No, you are saying
That is
several
state
things which
you have to
is
chat on now.
page 55 and 56. A matter was
I don't say and claim that I am from Orissa, so I should be given.
Absolutely correct. Coming from Delhi or going to Delhi is
tomorrow maybe
Submissions only outright.
tomorrow I have to hear or day after tomorrow.
Yes.
Not so Delhi.
When? 30th?
Sorry.
30th you come, we are fixing this matter and ensure that no adjournment is sought.
I submit myself to the council.
But after hearing the respective
It's not.
accepting.
I have asked formal denials, just formal denials to, I want to, nothing is carrying there.
Taken up tomorrow. Repeat and reiterate.
Manners, just denials, I would say.
And they have filed some documents also. Two documents they have also filed now.
Come in the next week, go through it.
Manners, in that case, I create a lordship, they may keep the tender process in abeyance. Because it's an absolute case of malafide, favoritism, tailor-made to suit a particular tender. And in fact, in previous occasions, exactly what I've served, in fact, another additional memo. They have replica case, they have fixed a high turnover, thereafter they have gone down and reduced it. And that is my case with my lordship. The reasoning they are trying to
I am
give.
praying for day after tomorrow. Day after
You
tomorrow.
have to know.
Yeah.
It's submitted by the company for this thing, then we have received a copy of the rejoinder. And she's trying to produce this. It is matter the list of the.
I have to talk to the
Before our name.
Sure. As you lost to lordship.
What top?
As it says, you lordship has.
This is already at the top, sir. It doesn't go on what?
Deeply obliged, manners.
Yes.
Item number 3.
So this is a public interest litigation may not.
Lordship, just smooth. They may not act in proceeding with the tender process because they have already opened the bid yesterday.
It's a lot, sir. They are tomorrow.
So this is public interest litigation may not. Herein the petitioners are the president, secretary of village committee as well as NAB support and all members of the concerned Gram Panchayat. Here may not, a wellness center is functioning since 40 years. Now state government has taken a decision for upgradation of the center and accordingly construction of a new building in centrally located with the Gram Panchayat may not. Page 12, the concerned CDMO wrote a letter to the Tahsildar to identify a land is centrally located to the Gram Panchayat. Page 12. Accordingly, tender was floated for construction of subcenter building of wellness center, page 16. Also, very important, also kind of page 16 in serial number 8. The serial number 8 is the construction of subcenter at Alanda under Krishna Prasad Block Miller. Now, Miller, the particular the construction shall be in the at Alanda. Now the construction are going to start in the 3 kilometers away from Alanda, which is not convenient from the people from the Gram Panchayat. More particular here, they decided to, the construction should be centrally located to the Gram Panchayat, which shall be more convenient to the people. Miller. That is my grievance, that should be in centrally located, not to the 3 kilometers away from the Gram Panchayat. Miller. They construct as per their tender. Miller. Page 16.
What do you say? Not going strictly by the maintainability of the PIL. Then
And I would take instruction in this matter, whether it is going to be constructed 3 kilometers in a distance of 3 kilometers or not.
Constitution in the nature of a public interest litigation is taking a
Pursuant to an advertisement under Annexure 1. Pursuant to an advertisement under Annexure 1, I applied online for the post of Assistant Professor Stage 1 in
the Advocate General is to be notified because you are assailing the virus of the state tools.
Rule 6.2.
They have to be notified. The definition is by assailing the virus.
in prayer. Let my application be processed subject to result of the report. Your Lordship may say any selection in the education.
Item 6.
The petitioner in this petition.
Sorry to. May be permitted to take notice to Public Service Commission also.
Yes, issue notice on other. Can you represent him or he has a
No, they have their own panel of counsel.
issue notice on the other response
Right.
of the partners. While you are recovers within 2 months,
By tomorrow.
they are giving you 2 days time.
Okay.
Note 6, sir.
Petitioner being an eligible bidder participated in the bid floated on the
Disqualification. On what ground your
my disqualification is under challenge so far the technical bid is
what
concerned.
what is the
Disqualification at annexure 5. Yes, see that is at annexure 5, page 95.
what they say?
That's, they say, I am not qualified as I have not
Not
fulfilled
fulfilling
the
the
pre-qualification
pre-qualification criteria.
pre-qualification criteria.
You are ARS infracted.
Yes, ma'am. Serial number 8.
Okay.
ARS infracted for
So what is the pre-qualification
the
criteria?
pre-qualification criteria. Let's see if we have a glance to the tender notice as clause 8, page 20.
Page
Page 20, 20.
20. Yes.
Clause 8, let's see at the bottom. The minimum eligibility criteria
Yes.
that requires I have to submit
Minimum
the
3 years experience.
I have 3 years experience.
At any major ports.
Everything I
Yes,
have.
use and such under the central government, state government, or reputed private organization.
Let's see, we have
One is
turn to
official
page,
certificate.
page 22. Let's see, we have to turn to page 22. The clause J, valid license of food safety and Standard Authority of India.
That is license of food safety, that is.
Yes. That certificate is lacking. That is their finding.
What is your,
On the basis of lacking, they
what is-
issued
what is-
later on
what is the
an
nature of the services for which the tender was got?
nature
Providing
of
food as
service
well. Providing food as well.
to provide hospitality service.
Including the
district.
food.
Yes.
Yes, that.
Let's see, we have a glance to annexure 3, turning page 83.
Yes.
After opening up the tender, they called me to produce 3 documents. That is at page 83.
Valid renewed.
Yes, valid, renewed, FSH copy, ITR, then declaration. These 3 documents were wanting, they found on opening of the tender.
That was not contemplated in the conditions.
Yes, that was contemplated in the condition. On the basis of that later, the next page, Lordship, I have submitted all 3 documents on the next day.
Yes.
They have received with acknowledgement.
Yes.
The page 84 is the acknowledgement they have received with their seal.
21st February.
Yes, ma'am.
What was the last date of submission?
That last date is 7/12/24.
Yeah.
But as per clause 21, they have to confirm that as per clause 21, page 23, running page 23, if they found some documents are wanting that is historic in nature, they can confirm.
Historic.
Yes, these documents are
Historic in nature.
because they cannot
The
say
historical values it carries.
that is it carries since a document is not changeable. That is
No, historical means what?
that is the clause Lordship page 12.
A renewal of the
23.
food and safety certificate is a historical document. I do not know.
That is their interpretation, Lordship.
Interpretation. Where is that clause?
That clause 21, page 23. The shortfall information at the middle of that clause. Shortfall information documents to be short only in case of historical documents, which pre-existed at the time of tender.
So it does not say historical.
That
It
is
simply says that if they want any clarifications to be done, they can request.
Fine.
So that time was there at the time of considering the bid.
yes. They confirmed that document, I have produced that. Subsequently, they found at annexure 5, Lordship, page 95, that is the disqualification. I am not qualified. But in fact, the present petitioner is continuing for the work since 2022 with the extension. And I have the certificate which I have produced at page 87. Let's see, we have a glance.
Pre-existing. We call it historical or pre-existing ones as well.
Why? You don't know the meaning of the English words. Historical documents.
I have produced
These documents
I have produced.
predated the date of application or your The three documents.
They call for the subsequent one, renewed. They call for the renewed one.
Clause 21.
Man,
It must be, it must be predated.
predated.
Means must bear a date prior to the date of last date of submission.
Well, it says
Yes.
at the time of tender opening. Pre-existing at the time of tender opening.
That means the document must exist on the last date of submission of the bid. So
That document was exist and I have
That-
submitted that.
that bears a date
But
prior to the date of
yes,
last date of submission.
yes, Lordship.
Can I?
Lordship, you have a
the
glance to
privilege of looking at it?
page 87.
It is.
Yes,
So then it is.
87 validation and renewal annexure. That is the FSSI certificate. Validity from
What
20.
is the date, sir?
That's Lordship at the top of the left side. Validity from 22/4/2024.
I'm just talking about the issuance date.
This is the renewal one. So issuance date is subsequent. That is on
Issued on 21 to
21 to
2025, sir.
2025. Fine.
So, and the last date was you said January.
No, that is December.
December.
December is the last date.
So
And that document was valid,
was it in existence? Valid as
Yes.
on that date?
was existence.
I'm talking about the validity of that certificate was till the last date of the submission
Yes, ma'am.
or prior to the last date of submission.
Prior to the date of submission,
It means it was not in conformity.
prior to last date of submission, that document was valid and also till that is valid, that has been renewed.
No. In the validity period is provided there. And it appears that on the day when you offered your bid, the certificate was not renewed or valid. It expired.
Not expired.
So what was the validity period of the certificate which you submitted?
Lordship, that is the page 87, that clears.
What certificate you produced and what for they want a renewal? Tell me first. For the year 2024, tell me what?
For the year 2024, I have the certificate that is FSSI granted in my favor.
Yeah.
That was valid till 21st April 2025.
So it was valid.
Well,
Then
then it is subsequently renewed from 21/4/2025.
I got you. Yeah, I got you.
Right.
Got you. So prior to the validity they had.
Yes.
So it was valid on the date of submission.
One.
Then why the third? Two other documents?
Two other document I have produced, that is the attached to the next page, that is page one is starting from page 89, that is ITR. The required part, then subsequently the next one is the declaration.
Did you submit the ITR?
Yes,
at the
madam.
time of bid?
Yes, madam.
What?
At the time of bid, I have not submitted. Subsequently, on his query, I have submitted.
Was it a condition precedent for submitting the bid, ITR, returns?
No,
It was not condition.
not conditions.
There is no condition.
No,
A, B, C, D, E, F, G.
no, ma'am.
Nothing.
No.
And then what is the third document?
Third document is the declaration, that is page 94.
Was it also a condition precedent?
No, man.
There is
That
no-
is why the authority called for again from me, since I have not submitted this.
There is a difference.
What?
One is that what are the requisite documents you should file?
Yes.
And second thing is that
What?
what are the more documents which you are required to file subsequent to the bid?
Yes.
Those who are not contemplated in the tender document or they want some more additional documents. That is another.
Yes.
So these two documents are not there.
Right.
So can I go back to that?
Yes, the requirement clause.
You were talking about page 20.
20. That is minimum eligibility criteria. Right.
Always number of direction of always number of fields. 30% of the estimated numbers. But there is a condition. The tender will submit the certified copy of the balance sheets and the profit and loss account or the annual income tax return. Assessment year for the last year means 22, 23, 23, 24, and 24, 25. As a proof of their financial eligibility criteria. That was required. Audited profit and the balance sheets of last three financial year 21, 22, 23, 23, 23, 24. Income tax return of preceding 3 years. These are all the statutory requirements. You have not submitted.
No, I have not.
Then
That
and
is
there
why
is a difficulty in cancelling the bid. What is the wrong?
that is why the authority called for.
Can they?
They have called for
Can they?
as per clause 21, utilizing to clause 21, they called for.
Instruction to appear, my lord. I've not got a copy. The only instruction that we have received, my lord, is the FSSI certificate. My lord has seen, I've only seen it on the system, my lord. The FSSI certificate that they said was renewed on 25 to 2025.
The earlier one is they submitted.
Absolutely, my lord.
His validity was till April 2025. So you could not have, you could have proceeded on that basis.
My lord, may kindly have. My lord, that is precisely what I asked for specifically, that you please give us that old certificate which you say is existing or valid till 25 to 2025, and hence they could not produce it. My lord, may kindly have. Kindly have Annexure 7, my lord, at page, my lord, page 98. My lord, may kindly have page 98. Paradip Port Trust, whatever I'm seeing from the record, my lord, I have not got a copy. On 15/5/2025, my lord, has it?
Yeah.
My lord, may see Paradip Port to the petitioner. With reference to the above cited, it is to intimate you for submitting the following wanting document which was not submitted at the time. FSSI copy which was issued on 22/4/2024. Because that was their claim, my lord, the 22/4/2024. This, my lord, may kindly see the reply, the very next page. They are saying, please find attached here with our letter come FSSI license. My lord sees it? My lord may see. They have not filed a reply. They have given a...
So they did not really give a...
The 22/4... I completely borrowed them. That is my instruction. That 22/4/2024...
Only they gave.
No, my lord, they did not give it. They have given an affidavit on 101, my lord may kindly see, that we cannot produce 22/4/2024 thing. 101, my lord.
Yes.
My lord may see, this is an affidavit filed by the partner of the petitioner. I am the deponent that as per your letter number such and such, we have to submit the FSSI copy which was issued on 22/4. We had downloaded the same at the time of issue. During the cleaning of our office, it was misplaced anywhere and unable to find the same. It is showing on the website. We are trying to download but unable to download the same. It can be verified online. Our license is valid and genuine. We are enclosing here.
So they did not annex.
That is my... They have not yet produced it. The 22/4/2024, which was existing or pre-existing at the time of opening.
Once pre-existing, there is no difficulty.
But that was not being produced, my lord. So we are not able to cross. That is my instruction, my lord. But if they give me a copy, my lord, I can assist your lordship of other things if your lordship wants.
Annexure 3 and Annexure 7. Both are letter issued by the authority. One C prayed for the valid renewed FSSI.
That will also augment the nepotism and the favoritism. If you issue a letter extending the time for submission of a document, that also has to be pasted on the angle of this Why? They will, if on the last date of submission of the application, if you do not comply the conditions of the eligibility criteria, your tender is required to be.
Required to be
It's
cancelled.
not difficult.
Yes.
How they can extend your time? They simply extend because of this paragraph 22,
21 days.
21. There they can say that yes, if there is anything, you can submit at the time of evaluation. But it appears you have not.
No.
And these documents, then can't.
So for annexure 3, annexure 7, I'm a glad. Annexure 3, they directed me to produce
Oh,
the
sir, you can.
renewed.
Please understand. Is it a historical document?
That is their interpretation.
So it's not a historical document. This document was wanting, they wanted to give you, but it does not mean that they will permit. Then everybody who has not submitted the letter should go to everybody. Extend the date of submission. But this can't be done. And the tender conditions have to be rigorously followed. This can't be done.
And how the authority, let's say how the authority issued annexure 3 and 7.
That's wrong. We'll say that's wrong.
Yes, and annexure
can't.
3, once they directed to produce the valid renewed FSSI certificate in annexure 3, so for annexure 7 is concerned, they directed me to produce the old one. Since I have not produced.
This is what is because it must have its pre-existence.
Yes,
And the bottom line of the story is that you did not produce any FSEI certificate
No.
at the time of submission. That's
yes, that is my case. I have not produced.
Once you have not produced, nothing. Then you come. No.
They have extended the benefit.
They
But
can't.
well,
Yes. Yes. The letter dated 17/4 for some other purposes.
No. Because I'm very on. No advice.
Item number 7. Item 7.
May please, Your Lordship. Through this petition, my lord, the annexure 1 is under challenge, my lord.
What is the initial one?
The annexure 1 is, my lord, the expression of interest issued by the opposite party number 2
Yes.
on 6/5/2025
For what?
for, my lord, issuance of a tender, my lord.
No, that is what it's always.
My lord, that is for the purpose of Mahanadi Waterfront Development
What is
Project.
this? What?
This is, my lord, the second paragraph. It is for the purpose of Mahanadi Waterfront Development Project in different phases, my lord. And the cost of the project is around 45 crores from what, my lord. So there are two expression of interest having the same number, that is EOI number 4910. One is through offline publication, another is through online publication.
Then the variance in both.
Yes, my lord. There are discrepancy, my lord.
Humility matters. Yes, my lord. With due humility matters, my lord.
Printed copy, publications.
Offline is H14, page number 14.
That is a 20 marks. Where is the
Offline, my lord. That is there. Page number 19, my lord.
19.
19. It's third. 15.
Page number 19.
19.
In the
Is in online version that is 45. In offline version it is 35.
So have they issued a corrigendum?
May I humbly submit my lord.
It's a corrigendum, some ministerial.
But it's not that. It's not that my lord, what my learned friend submitted, my lord.
What?
It's not that what my learned friend submitted. But fact means my person to direction minors have taken instruction. Annexure 1 my learned friend refers to was never issued at all.
Huh?
Was never issued at all. No offline publication. Offline publication was to refer to annexure 2 only, and that is in online.
Only online.
Only.
There was no offline.
No.
So from where you get it, sir?
No, that is what exactly my city explanation.
Then
From where you got it?
And the
He
second
says that there was this offline was never published.
published.
From where you got it?
The offline publication minor says that you refer to that there's also one.
The only small
Small.
dispute was 20 and 15.
Yes.
From where you got it, sir?
my lord, that is
That was a
I
draft.
will take it to
No, he says that this particular which you are relying was never published. They never issued it, only online.
But the second part is very important, my lord. A person to matters online publication, high public government central government concern applied. All 5. Minus out of
State
that
government or the central
central
government?
government.
They applied.
They applied and one of them got selected. And the LOI has been issued.
It's a different.
But
His challenge
but
is very
Yes, sir,
restricted.
challenge is that then
His challenge is restricted.
exactly minors.
Can only go.
Exactly, that is what minors require, that you issue a corrigendum.
That's the only problem.
whatever is there here, there is a signature, my lord, in page number.
That is what is there in our file minors preparing draft. They collected it minors in some other way and they are utilizing it. But fact is all.
That is how it is often, my lord.
Most
Government
peculiarity is this.
So whatever is there, we obtain from the office
Even
itself,
good, as much I checked it.
my lord.
How can you obtain a draft? Draft is
That is
preparatory
no, my
step.
lord,
draft is a preparatory step.
Absolutely, but here, my
Not a
lord,
final thing.
what I
So
see, my lord.
there may be an alteration, there may
Absolutely,
be
my
one
lord.
thing that.
Absolutely, my lord. But the thing is that there is nowhere it is written that it is the draft or it is final.
Where from
in the
all
offline.
that?
So we obtain this particular document from the
Cannot
office
define
itself.
the existence of a document. You can't ask him the source. Are you aware of that line?
Well, that's correct, sir. So I don't dispute of that, but
If you say it's not a genuine, then definitely,
Yes,
then we will watch
that, but I
source.
am on that.
The genuine document, but you say draft.
I say my humble contention, so far online, that yesterday also I checked it, this online refers to annexure 2. And pursuant to annexure 2, all 5 minutes we have responded,
Oh, fine. Don't have to enter it.
that has never.
What readings?
Then, my lord,
We will record a.
submission.
Can you give a short affidavit
My lord,
that this document
kindly give me 7 days time.
was never published
Yes.
anywhere
Yes.
in a physical form?
Yes.
It is only the
Eaten.
e-tender.
Physical mode, it was not published. Not in paper, newspaper, and I will also enclose
Sir. Can you find it day after tomorrow?
after tomorrow.
The matter at the time of taking up the Yes. Yes, got it.
Item number 8.
Then you are saying, item 21, you are saying, Mr. Naik is some personal difficulties, you are saying.
Yes, remind us where it is got.
May you are saying one I is not listing.
Just remind us.
Item number 8.
Pendency of this application. See, development was made because we are challenging the notice of termination. By the time they have already terminated the contract,
Okay.
and I have filed an application, interim application 11756 of 25. Already filed and copy to sought to my lord and friend for sought for an amendment of the, we incorporate that.
Have you served the copy?
Yes, madam, I have already served.
908 is an amendment application.
11756 by 25.
908 caveat.
That is caveat.
Oh. What amendment you want to make?
To incorporate that prayer, may not that termination order under Annex of 21, I want to incorporate this.
This
And so
has happened during the pendency of
Pendency of the
subsequent event. Has to be. This is an application for amendment of the resolution and the biggest for the.
When I challenged the annexure 4, the technical evaluation committee report that they have disqualified me as per the clause 113G of the DTCN. My technical bid has been rejected.
Your serial number 4.
Serial number 4.
Rejected technical disqualified by the PEC as per DTCN
113G.
clause 113G.
113G is my lord.
Where
At
is
page,
it?
at
Where
page
is it?
62.
Page?
62. The mayor place.
No, sir.
Just 1 minute.
Sorry.
62 is? No.
No, it's 1 minute.
Huh?
1 minute, please.
Under 13G.
13G.
Should have satisfactorily completed one similar
Natural work
consisting of
not less than 30% in project during the last 5 years. My lord, at annexure 3, page 100. I have given the certificate, my lord. It's for their
100.
100.
Yes.
The office of the superintendent engineer, Ganjam R&B division number 1, Barampur. Construction of classroom of KTS Ayurvedic College at Anguspur, light block.
Value of the contract is 64 lakhs.
64 lakhs.
Which was the other side?
No, but while London was showing page 100, 93, 94, your lordship may kindly see, this is part of the DTCN. That is totally empty. Page 94.
This is a copy of the DTCN. There is not any document.
Oh, this is a
Copy.
copy downloaded.
Downloaded
It's
copy.
not filled up.
And that is the 100 malad.
Take
And-
instructions and come back. If it is there, then why?
Yes, ma'am.
Necessarily encouraging the litigation.
Yes, ma'am. Gentlemen, definitely, sir, not there. My friend is not there, that is why I am looking. Your lordship, I'll take instruction.
The
Like this public interest litigation is aiming to bring your lordship's notice about the self-immolation of a female student in front of the principal's office at Fakir Mohan Autonomous College, Balashwar. To assist your lordship, I have prepared a date chart. I want to take your lordship to the date chart, that is Appendix 2. And I'm reading out here. On 12/7/2025, a 20-year-old girl student who was pursuing the B.Ed program had set her on fire after pouring petrol on her outside office of the principal during a student protest over non-redressal of her grievance against the HOD. In the same day, Samir Sahu, head of the department in the education department, who is the prime accused in the sexual harassment case, was arrested. On 14/7, the girl student was declared clinically dead at about 11:46 p.m. as per medical report issued by the AIMS Bhubaneswar. On the same day, the principal of Fakir Mohan Autonomous College, Mr. Dilip Kumar Ghosh, was arrested.
Thereafter, my lord, on 15/7/2025, press release by Indian National Congress through his Odisha with a press release has been released. And the very same day, in response to alarming media reports regarding the alleged self-immolation of a student of the next page, I am Fakir Mohan Balasore, Odisha. The next page, ma'am. Balasore, Odisha, reportedly due to harassment by faculty member, the University Grants Commission by the office of order number dated number.
From where you're reading, sir?
Madam, I'm reading from the appendix 2, madam, date chart.
It chart I am looking at it.
Yes, madam, the next page.
But I am unable to.
B and C, madam.
The words which you are uttering, who have been written there.
And B and C, 2 pages are there, madam.
I am looking at B and C, sir.
This is continuation of paragraph number 6, madam.
Nothing about is relating to the delay in the revenues appeal, which is beyond 6 months, which is a period provided under 107 subsection 2 laws for the state. And in my humble position, the appeal has not been accompanied by a delay condemnation petition. This barred the limitation as per section 2 of section 107 laws.
Is it necessary to have an application?
But
It is necessary to have an
the original period for the state is 6 months. And in case there is an application, there is a condonable period of another 1 month. In this
application is mandatory.
No. But a move has to be made that this has been filed.
This is what is required.
Month.
So then gone beyond 7 months.
It's beyond 7 months.
The power to condone is not there. And he has condoned or what?
No, he has not. And the appeal lot has been fixed for hearing without
Condoning, going into the question of limitation.
without going to the question of limitation.
Appeal is fixed.
Sorry.
The appeal is fixed for hearing.
The appeal has been fixed for personal hearing notes. At that stage, I had come
That means on the merit.
on the merit.
Without condoning the delay.
And
Raise
unfortunately,
that issue. When it is fixed.
It was fixed notes.
12/11/2024 also. 12th November 2024.
Thereafter, what is that?
Then they filed it before the High Court and then.
There's an interim order. There's an interim order dated to 2nd of December 2024.
Not to
Proceed further.
then 5 years, then the interim order is still the prayer of the
No.
Both the matters relate to section 73(4)(b) of Finance Act.
What is his challenge?
Yes, Madam. Because
Limitation problem.
Limitation.
yes,
It is pending before the Honorable Supreme Court.
yes, Madam. Today, Madam, that matter is before the
So
Honorable.
what has happened?
It's
You have to
not
find it
released,
out.
Madam.
It has not come out, the order has not come out. The sub items are.
Yes, because that order because I have given is that 2/5/2025 order.
Item 17.
Now, petitioner before your lordship, it is the proprietor of the company. He has of the company matters. Proprietor of a my lord, he is a my lord, proprietor of the Baba Enterprises. I have given my written my lord in my cost title. He is a proprietor of the Baba Enterprises. He has two GST number, and he has to deposit the amount, the GST amount, in the general GST number. Instead of depositing in the general GST number, he has deposited the amount, TDS amount, in the TDS GST account. For that reason, my lord, by mistake, my lord, he has deposited because number is same and 4-digit differences. For that reason, my lord, at present he is facing that his dues are not released in his favor by the opposite party number 2, for which he has filed the repetition before the opposite party to release the dues, but they have stated that you have wrongly deposited the amount, the amount by in general GST, in TDS GST instead of the general GST. For that reason, I am reporting a lawsuit. Paragraph 1, my lord, can give a glance, and paragraph 9, I have detailed mentioned. Paragraph 9, my lord, that the amount of TDS GST which has already been deposited by the petitioner in the account of the opposite party number 2 in his invoice number so and so for the financial year 23-24 dated 21/6.
What do you say?
The lordship, let me serve a copy. He has made a party to Union of India.
Yes, we are appearing, my lord, in this case. It is listed for first time, and I will take instruction. They made a party to the Secretary
What you will do?
Revenue.
What you will do? Your Union of India has negligible role.
Oh, we don't have any rule, and they made a party to the yes, GST authority has to do it. Mr. Kedia is there. They let them made a proper party, and Mr. Kedia may appear.
It's supposed to be very innocuous. And that he has to deposit in a particular account, wrongly deposited in the another account, which both the account belong to you.
Yes, I agreed lordship without having a copy with me.
For that reason, I have
And we are not the party in the case also, lordship.
You made a party to the GST, then only authority, and then only can acted upon.
Yes. Keeping this matter on Monday next.
Right.
Give him a copy.
Lordship, let them make a party also.
Pretty much party.
Central mystery.
We have filed the representations, my lord, before their office, my lord, but it has not been considered. For that,
Whose office?
that opposite party.
Who is the opposite party?
Rail Vikas Nigam Limited, RBNL. RBNL. Rail Vikas Nigam Limited at 6.9 acres complex, Bhubaneswar, at post date Bhubaneswar, PIN number test program.
Then why you are raising a dispute of GST in the TDS general account and the general account.
My lord, because both the accounts are maintained by the opposite party number 2. That our general GST and that is also the TDS GST. Both the accounts are pending before the opposite party number 2. Instead
How
of
can they maintain that account, sir?
GST money.
How can they?
Oh,
RBNL may have put the GST in the wrong
yes.
GST number of the dealer. May have, I think. So they have made the representation to
Yes,
RBNL.
ma'am. We have also made the representation.
All the money will go from you.
Yes, ma'am.
Why you will not make them a party?
We have
Complete them a party.
Yes, ma'am. Also, this matter belong to state GST. Administrating officer is state GST. I mean, I think the part of state GST.
State GST.
I do the step.
Yes, dear. Complete them a party.
Yes, ma'am. I will file the consolidated cost title, include them as opposite party number 3, state GST.
Whom to be made a party? Commissioner?
Commissioner, ma'am.
What?
Commissioner. Made a party. We'll give the details.
No, give them. Leave is granted. Leave is granted to the listener to add.
Yes, ma'am.
Item 18.
By tomorrow, my lord.
Item 18, Your Lordship, may I please? I'm on VC.
Go ahead.
Yes.
This is regarding registration cancellation, Your Lordship. Item 18.
Give that.
Thank you.
Your seat.
Yes, my lord.
Item 19.
Item 19
also RC cancellation. I have seen that.
Cancellation. I think cancellation. Yes, when you see, you might.
Item 20.
I've got the 2 decisions of the Honorable Supreme Court. The Honorable Supreme Court has directed that for delayed payment, there is no interest and the interest has to be paid. So also candidate. That yesterday's matter where we are so.
Here, I could not point out the SPML. Here, the UP number 3 should be put under notice because the cooperative society where the petitioner was working and that matter was carried to the Supreme Court. Now, the UP number 3 filed an affidavit before the read court. That affidavit is also a part of record. You will Lordship will find it.
Have you served the notice on OP number 3?
No, but yesterday it has come from your part, Lordship said that please to direct me to file it. So that
He wanted to decide the matter immediately.
yes, that's why I'm afraid. If my friend wants the notice, it's there, functionary.
Cooperative bill is a separate body. If your Lordship will kindly see page 45, they were represented by a council and they filed an affidavit for the
Notice on it.
Yes, sir. Is returnable after 2 weeks. Yes. Against you.
My friend knows me.
No.
Yes, obviously.
He
Will have rather complicated with the judgment on the question of delay and in a
will hide.
reproduction.
According to you, he will hide. He will not disclose. No, he will disclose. Yes, call the name.
Item 21.
I take notice to open for 3 only because my friend will have for other of this.
Yes.
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 21.
Item 21, you know, says, issue 9 with difficulties, you know, says. In this case, you know, says, Mr. Misra is appearance, may permit to find the appearance memo, you know, says.
Your lordship will mark on the last 4 occasions. Taking from plea or the other keeping it. I never object to adjournment. But your lordship, I can remember.
Have they got any interim order?
No.
They have not. So what is this matter?
May I pray one thing, your
21.
21. Yes.
May I pray,
Which order they are challenging?
may I pray one thing.
Available at pails. Is available at page 100. It starts from page 150.
That what is the nature of the orders study? What your single bench has said? Or again?
Your lordship, remember from the last one I was pointing out in a writ petition, the order which has been challenged in this writ appeal, that was acted upon. A consequential order was passed. That was challenged in another writ petition. Thereafter, now, can he file a writ appeal challenging the order passed in this WPC? And then
against the consequential order?
Yes, your lordship kindly see this order.
May I pray your lordship that one IA is not listing. So may I pray your lordship kindly list in IA number 2903 of 2025.
No, that WPG 4774 of 2025, that order has been assailed in this writ appeal. WPG 4774. Now, in this order, your lordship may kindly come to the second page, para 5.
Yes.
It is the case of the petitioner that petitioner was before this court on an earlier occasion in WPG 4774 of 2025.
Yes.
This court right ordered so and so when disposing the matter passed the following. Now, your lordship, straight away, your lordship, if your lordship comes to the internal page 4 of that judgment, para 6.2, the directive portion. Internal page 4 at the bottom it is written.
Yes.
6.2. In that view of the matter, this court, while disposing of the petition, directs open part number to issue a fresh SOCA to the petitioner along with reports submitted by the Vigilant Cell, along with all enclosures thereto on the appearance of the petitioner before the committee on 21/3/2025, along with copy of this order. On being provided with the SOCA along with the report and other relevant documents, petitioner will be allowed 4 weeks time to file his reply. On receipt of the reply, the committee shall decide the issue and dispose of the matter finally, strictly in terms of the provisions contained under aforesaid 2022-23 rules, as expeditiously as possible, preferably within a period of 6 months. If there is no other.
That 477 or whatever.
Yes.
4774 is disposed of.
Yes, disposed of.
He has challenged this order.
Now in the writ appeal, he is challenging this order, but in terms
This
of
order.
yes, in terms of this order, another the 12/3/2025 order was passed, which was challenged in WPC 9959, which I have given to your lordship. That is available internal page 5, para 8. The resultant order pertaining to 4774, that is available para 8. Having heard and counsel appearing for the parties and consider the commissions made by
this order of 12/3.
Sorry, 12/3/2025 is the order. 12/3/2025 is the order which
by virtue of which punishment was inflicted upon him.
12,325 is not the punishment. It is a product of the order passed by your lordship in the earlier petition 4774. There your lordship directed to pass order. This is the order
You
passed.
said everything is to be done.
Fine.
Shuko's notice will be given.
Fine.
Everything was directed to be done.
Fine.
So what is that 12 order?
What I was intended to say, this 12-3 order has been passed in this judgment. So how come
4774?
47744, 4774 order was acted upon, and 12-3 is the resultant order. That was challenged in this judgment, which I have given to your lordship, 9959 of 2025. Now thereafter, can he file a writ appeal? Thereafter, he has filed a writ appeal. Now that has been acted upon. The order has been challenged in another writ petition. That has been quashed. No, we have not replied that since my learned friend filed the writ appeal, thereafter on 4 occasions he has been taking, your lordship may kindly remember, that is before the scrutiny committee, state level scrutiny committee. One day he submitted that, tomorrow in the scrutiny committee, your lordship said that let him face it.
Is there any interim order, no interim order? Then what is the difficulty in proceeding?
I don't have any difficulty over there.
Let them go on taking a time, but you proceed.
May I pray your
Since your lordship wanted on the last occasion, directed me that let him face the state level scrutiny committee, let the result come, thereafter we'll see. He has been taking time on this plea that tomorrow is the state level scrutiny committee. Thereafter, on the plea of health, he has been taking time for the 2-3 hours.
Your lordship, the contending counsel is Mr. Naik. He is ill today, your lordship. And Mr. Misra is appearing in this case, your lordship. I permit to file the appearance memo, your lordship.
Who's the appearance memo?
For the appellant, your lordship, Ashutosh Misra.
He will be appearing.
Yes, your lordship. So
when?
Your lordship call on any date, your lordship.
Today?
Friday, your lordship, may pray to take an Friday, your lordship. We are ready for that. Your lordship, one thing I pray, your lordship, kindly along with the IA number 2903 of 2025. And take up this matter on Friday, your lordship.
Since
That IA, your lordship, IA number.
It will be. Item 22.
On behalf of Mr. Das, my lord, I take no day after tomorrow. What? SK Das, on behalf of this. Take no day after.
yes, what you say?
The delay already controlled.
Item 23.
Item 23. One connected WA number 970 of 2025. Maybe taken up day after tomorrow. 970 of 2025.
Not listed.
It as well as connected up. Same price.
Anybody?
970 of 20.
Then this part of the district, now we should do it 900 of
970.
970 of
25.
2025. Next week, Monday.
Item 24.
Condonation of delay.
Our
But delay is
700.
No, madam, it's more than that. But in the first round, matter was carried to the Supreme Court. After review, matter was carried to the Supreme Court, then Supreme Court again remanded that matter. So since the IA application which was filed earlier did not properly explain the delay caused after the matter was remanded by the Honorable Supreme Court, your Lordship granted liberty to file a better application.
Yes.
So in that view of the matter, we have already filed that, my lord. That is,
Have you received?
Yes. I have also filed objection.
we have filed their objection.
Yes, I have objection.
You got a particular?
But that objection, my lord, I have filed. And then, it's filed. Yes.
I have explained that.
After disposal of the SLP, again, after 4 months, they filed it. After 4 months, again. They have withdrawn the matter with the liberty to upload minors. They have filed a review. But filed a review of the again, after 4 months, they have filed. And no, nothing is mentioned in the petition. I kindly see regarding the delay. Only because official.
No. That is explained. Your Lordship may kindly see the IA. Your Lordship may kindly see.
You know, just I give the entire deadline.
Para 6 and 7. IA 2988, my lord. That is there in the list.
It's there. Item 24.
Yes. There is flag C, my lord. Flag C.
No objection, actually.
Supreme Court order that is quoted in para 5. So Lordship will come to para 6 and 7. 6 and 7 is post the order passed by the Honorable Supreme Court. We have explained that immediately after disposal of the SLP, the Government of Odisha and the Department of School and Mass by letter number transfer authorized the education officer to file the appeal.
Oh, you approve this FX code directly from the single being judgment.
Yes. So that is why we
And when the special petition was discussed,
that we have quoted that order I have enclosed, that is on 23/8/2024. Permission was granted. It was withdrawn with a liberty to.
so it says would be entitled to avail the benefit of section 14. So what more? Now, after this 23/8/2024.
Yes.
What do you have?
Para 6 and 7. Para 6 and 7. Finally, there's that.
Finally, okay. Understand taken pending about the.
In between, there was a change of panel of and Advocate General Office. There has been some.
And see, dates are given. And even the entire date, madam. 4 months, nothing has been done. They have only written that the matter is pending before the arbitration office. I will give the entire date, madam.
Matter is pending before?
They are standing in the petition that the collector Rayagada authorized the DO to file the appeal, and the DO have presented the appeal, DO given all the documents, and we have kept pending with the arbitration office for long, for 3 months. Nothing has been mentioned there.
No, they after the dismissal of the special petition, granting them the leave to file a complaint. Then immediately within 15 days or 5 days, they approach the authority. The authorities have thereafter when they gave the file came before the legislature, there was panel of the advocates, somebody was interested, thereafter there was a change of panel. After the change of panel, again, it has gone to the IG. Again, his name is recommended. He took time, was also busy. That it appears.
Up to my.
He took time to.
I have given,
What can be done?
I have given my objection up to matter. And
He
that
could have
too.
done it within 2 days.
Within.
But he has consumed a considerable time to prepare.
Up to matter. I have only given the objection that despite our episode, up 1 month they should have filed. They have filed after 1 month. That I have. And that too, the order has been complied in the meantime. The original order, yes, they are collector complied the order, directed to regularize. Thereafter, they are going to, they have the government after sport.
The government has also regularized it.
Collector, the authority, Ragana, regulation services. Thereafter,
Getting a regular pay.
no, thereafter what happened? Government, the collector, by order of government, order cancel the regulation. I challenge it, and that is cooperated by only single judge. That is never challenged. The order of collector withdrawing the earlier order regulation has been caught by one single judge in 2023. Never challenged the authority. That I give specifically mentioned by my objection, madam.
So let us condone the delay and dismiss the appeal.
I have only subject.
That's not difficult.
I have only subjection my notification.
Yes, on appeal.
And regarding that compliance and further passing by the honorable single judge and not being challenged, that is not within my knowledge, my lord. That is not within my knowledge. The Lordship only condone the delay. Let me take instruction and produce it. If it has happened, then it has happened. Well, if not challenged, then he has to get the benefit. That's fine. I'll just take instruction from the authorities regarding.
For the inquiring
Here in this case,
Just says the BL cannot be a criteria.
that is not the case.
That's not a case.
No, no.
No, what is the case?
That's it. In the advertisement, let us stipulate that 1 year course only they can apply. But let's say with applicant and other similarly situated person, they had 2-year BAD. And since 2014-15 onwards, only 2-year BAD is being imparted in state of Odisha and other. And NCT has clarified that 2-year BAD is equivalent to 1-year BAD, and those persons possessing 2-year BAD, they can be given appointment on that basis.
There his case was rejected on the ground that he was having only 1-year BAD.
Right.
That was the case before the division bench of the Supreme Court. The division bench came to a conclusion that higher length of 2 years BAD means length is more. Why should it discard those persons who have acquired 2 years BAD? So that has been allowed. That
has been a shorter, I can remember.
Yes, that's what is the finding in this bill.
Also, let's say 2-year BAD is being imparted.
It is finally disposed of.
Listen, the first commission by. Item 26.
Item 26.
My lordship, please issue notice and limitation.
Yesterday we have acted for the respondents, so 1 week time may be given to file an objection to the condemnation of delay.
136 days.
And only yesterday our name has not been reflected. Yesterday we have already acted. So I think next week. Next week, this is a pensionary benefit matter. So 1 week time is given.
For one good reason you want to file.
Yesterday only we acted. So next week you'll also put it in next week. Next week. Yes. Objection to that condemnation of delay.
Next week,
All right.
in the region counter. Is appeal. Let's wait for election to file counter. There's a counter, they will file in the week.
Item 27.
Yes, numbers of retracts have been filed.
Yes.
12 numbers of retracts were held.
Where's number? Why?
All are listed now today. I have
appearing in all 12.
Yes.
So 12 appearance.
Yes. I have filed 3 applications only. One interim application is to grant leave to file an appeal because I was not made a party in the petition.
So how you are affected by your orders?
Affected, my lord, we have purchased the land from the owner who the land has been settled in favor of the vendor of the petitioner in 1990. In a proceeding of BPA case, my lord, that is a Bay Bandobasta case, village police.
What Bandobasta case?
Bay Bandobasta, which has not been settled.
Okay.
Well, that settlement was made on 26/4/90. Rent assess, everything, salami, everything has assessed, and the deposit was made. Thereafter, ROR was published in the name of the vendor of the appellant. Immediately thereafter, after 3 years, those persons have purchased the land. Who are appellants? Those who are appellants with Guru Lordship.
Oh.
They have purchased the land.
From him.
From him. Then there are 2 persons.
Yes,
From
then?
2 persons, they have purchased the land.
Then?
That thereafter applied for mutation. ROR was published in their name. Thereafter, my lord, they have filed a 8A application, 8A OLR Act. Land was, my lord, converted from agriculture to homestead.
Right.
But in the meantime, the person who has got half of the land settled in his favor, half land settled in the vendor of the petitioner, and half land was settled.
Say that.
Mine.
So,
He has filed appeal, revision, everything. But these petitioners were never made as parties.
Appeal for what?
Well, settling the 50% land in favor of the vendor of the appellants.
They are challenging that particular order of settlement
Yes,
in the favor of your vendor.
yes.
So your vendor must have been a party.
No, he has also not been made as a party. And my lord, everything, my lord, in the revision also, it was brought to the notice of the revisional authority that these persons, in the revision they have made party. It was written that the land has already been sold. Thereafter also they have not made parties.
Your vendor says that it has been sold or they say that it has been sold. Your vendors said in the original application that he has sold the property, or they pleaded in the original application.
No, my vendor.
Oh, your vendor said. Then
In spite of that, they have not made parties. ROR has already been published. They know that the land has been recorded in favor of the purchasers. They have not made party to any of the proceedings.
Then what happened?
Thereafter, my lord, they have filed an application. Thereafter, my settlement, the vendor settlement was set aside. Yes, set aside.
Then,
After
on the basis of the order of
this honorable court remanding the matter to the original court, Tahsildar, to consider the claim of the 50% holder of the land. In that case also, in the writ petition also, we are not made parties.
then
my lord, when that the entire land was settled in favor of the another person, he has filed an application for mutation. That was rejected.
Rejected?
Yes. Against that, they have filed a writ application before this honorable court. In the writ application, it was directed that since in the BPA proceeding, the land has been settled, you have no authority to reject it. And it was directed to record the land in his favor. After it was recorded, they came with a JCB, tried to demolish our structure.
They filed a writ petition whether you were a party.
No, where, my lord? Since 2012.
Then how you come to know?
Because after recording,
JCB,
he used a JCB to demolish the structure, the house, everything structure. Thereafter I got into and filed the appeal.
Came with the JVC?
JCBs. Yes, ma'am. I have also produced the photograph before this honorable court while the matter was listed. And there is 65 days delay. 3 applications. One is for grant leave to file an appeal. Second is, madam, there is a delay of 65 days.
Now, this order you are challenging, which order you are challenging?
The Lord Single Judge order, my lord, passed in under the Subway Settlement Act. The Lord Single Judge should have neither the settlement or period started nor extinguished.
What is that? I know. But what the order is passed by the single bench in a writ petition
to
change the ROR, which you are challenging.
Yes.
With the
No, I have received
copy of the orders.
I have received notice on behalf of respondent number 4. In all
He is a mystery monger, respondent number 4.
Yes, ma'am.
And the writ petitioner before the honorable single judge. But all the 3 petitions, but the main issue would be to grant leave. That is what is the right, because if she's not a person agreed, lordship. But so I appear today, I will file a declaration. What has happened, Lord? The vendors were parties to the case which went up to the Honorable High Court, where they lost title to the state. All these lands were vested in the state. The High Court gave a direction that parties can approach the government for settlement of the land in their favor.
That is what he says.
Yes.
The vendor was settled, given a half of the property, and the half of the property was settled.
There is no conflict there that I will disclose.
So says now the vendor in whose favor the half of the property was settled, he sold those properties to the.
But by the time he had lost the title to the state, that is what.
Now in the proceedings initiated.
Yes.
According to her, no, his vendor or their vendor.
No, vendor.
Application.
No.
Where in the revisional proceeding, the vendor disclosed that I have already sold out my portion of the property.
I will give that on.
I have no semblance of right
No.
taken and interest now.
I'll give that on affidavit. 2006.
Yes, madam.
Yes, madam.
2006, it has been
This is what
decided.
I understood from her.
But I'll give the documents. I will file my counters to the, because that will be.
Because they are not a party, they do not know. The knowledge is derived from a particular day.
But if their vendors have lost title to the state by virtue of orders passed by this honorable court in which their vendors were parties. So
if their name was already recorded.
no, that time it was not. That time.
If there is an order which really reverses those entries, then they will be regarded as a.
Regarded, but once it has been adjudicated that
But
including me.
They have a right of appeal.
No,
Being a person aggrieved, are they not entitled?
No, that's what I'm saying.
Whether they will succeed in the appeal or not succeed is a separate issue.
That is
Right to appeal, how can you
so far as because my objection to locus stand, I want to put it on record.
What locus?
Lord, I want to put it on record, Your Lordship. Because
Right to appeal, you can't stand in the way. The law is well settled on the.
If he is a person aggrieved, so
if
therefore,
if a minuscule part of his right is
I will show to Your Lordships.
Then he has a right.
Lord, I will show to Your Lordships. With the leave of the court, he can appeal. He can appeal with the leave of the court. I will just place on record the documents which are.
What for? Sir, I am just asking. Will it defeat his right of appeal? I am asking.
But
you may defeat them on a merit.
But that's true.
You may defeat him on merit, but can you curtail the right of appeal? I am just on that. We are at the very primitive stage of a right to appeal.
But if I convince Your Lordships that they have no right to the property, I think Your Lordship will be convinced that they have not.
Only one thing is certain, if I correctly understood from our argument, that their names was reflected in the record of right.
Names are recorded, but after
And
record.
by this order, the direction is passed upon the authority to change the record.
No, that is
Let us see the order.
Yes, Lordship sees that order. And that too, Your Lordship for a moment.
30th January order.
30th January.
Yes.
Your Lordship.
Your Lordship, kindly say.
Kindly visualize for a moment. Suppose.
Just have patience.
Suppose.
Let us see the order.
Yes.
Yes, madam. Case 85.
Is allowed.
This is a consequential order. This is a consequential order passed in pursuance of a decision passed by the Honorable High Court in a separate writ petition. In a separate writ petition, it has been adjudicated, and as a sequel to it, the court directed, since the High Court has passed the order on merit, you implement it and correct it. Previous order has not been challenged. The actual order in which they have lost title in 2006 and 2015, they have not been challenged.
That we will see to it, but here it appears that there is some invasion on his rights.
No, on his right means by virtue of purchase. So purchase means can he have a better right than the vendor?
No, I am conscious of the legal basis.
So therefore, can he claim a better right than the vendor? So if the vendor has no right, he falls to the
legal principle is nemo doubt, court non-habit.
Yes. No, court has committed no mistake.
No. Nemo doubt.
Yes,
court, QUOD, court non-habit.
Yes.
A person cannot give you something which is.
Doesn't have, cannot.
But anyhow, if the consequential order which you are talking about, if that affects their right, can they?
Lord, I am asking one question to myself. Suppose this order goes, the earlier order stands.
Whatever, that will take care of. they will declare.
Lord, may I suggest one thing, Lord, subject to your Lordship's consideration? Lord, your Lordship may keep it one day for hearing.
We are hearing.
No, Lord, on the merit of the case. On the merit of the case.
Then we'll have to grant them a leave to file appeal. And once the leave is granted, then the appeal is regularized, then we can hear on the appeal. On merit.
No, what I'm saying that at the hearing of the appeal, your Lordship may keep it open to press my powers on the
No, that is what is always open.
That your Lordship may, because granting the leave, I cannot challenge her locus conduct.
We are just condoning the delay today, and we have to put this matter, they are also for leave to be granted. Right?
Protecting me, ma'am.
Got it. Delay has got people.
This is an application for confirmation of delay.
leave to appeal subject to my objection before the hearing.
Troubling me, IR 1981 capitalized troubling.
No. What I'm saying,
That leave to appeal, the leave to appeal cannot be a conditional like a summary.
no. What I'm
Leave to
then,
debate can be put a condition.
then your lordship may give me chance to file my.
That is what I'm saying.
Yes.
So when I can fix so.
About a week or so,
Next week.
10 days your lordship may come, 10 days. Date may be fixed. Interim order has expired since the reopening because it is still reopening. Interim order is not there.
Yes, not there.
Till next date.
No.
Till next day. Till next day. Till the next day.
Later link. That was given shall be maintained, but is still his next date and next date is today. This is good. But
excuse me.
But here,
Till next.
but so far as the leave is concerned, I am fine.
Yes.
The lordship will excuse me. Item 29, the lordship directed the matter to listed another matter. That matter has not come. So may I praise that matter may come up along with that district melody. Because I will be pressing my IA there.
Yes,
Want to play? It's the number.
As per item 20, lordship, kindly two more lordship, item 30.
We'll take up the rest of the matter.
Get lordship.
Want to play?
Get.